stop. If you are thinking about adding your son or daughter to the deed of your house, do not sign a single paper until you watch this whole video. That one signature could cost your family tens of thousands of dollars. It could even put your home at risk if your child ever gets sued, gets divorced, or files for bankruptcy. I know that sounds scary, and I am not saying this to scare you for no reason. I am saying it because thousands of seniors make this exact move every year with good intentions, and many of them find out too late what it really costs. By the end of this video, you will know the 3 biggest dangers of adding a child to your deed, and you will know 2 safer ways to get the same peace of mind without the same risk. Here's the promise of this video in plain words. Adding your child to your house deed can trigger a hidden tax bill using IRS Form 709. It can strip away something called the step-up in basis, which could cost your kids a huge chunk of the home's value in capital gains tax the day they sell it. And it can expose your home to your child's creditors, lawsuits, or divorce, even while you are still alive and living in it. Those are the 3 big dangers. Stick with me because I am also going to show you 2 tools that many families use instead, and both of them can be set up without putting your home on the line. Now let me tell you quickly why you should trust what I am about to say. I study tax rules and estate planning rules for a living, and I break them down in plain English every single week on this channel, especially for retirees and seniors living on a fixed income. I am not a lawyer, and I am not your accountant. Nothing in this video is personal legal advice for your exact situation. Every family is different, and state rules on deeds are different too. What I am giving you is the general roadmap, so that when you sit down with an elder law attorney, you already understand the questions to ask. That alone can save you money, because you will not be paying a lawyer just to explain the basics. Now, here is the part nobody talks about. Adding a child to the deed feels like a simple, loving decision. You think, my kid will inherit the house anyway, so why not just add their name now and skip probate later? That logic makes sense on the surface. But here's the problem. The moment you add your child's name to the deed, the law does not see it as a future inheritance. It sees it as a gift, right now, today, while you are still alive. And gifts have rules, big rules. Rules that can catch families completely off guard. If you are a senior with a lower income and a modest home, you might be thinking, this does not apply to me, my house is not worth that much. Please keep watching, because some of these dangers, like the creditor risk and the Medicaid risk, do not care how much your house is worth. They can affect a modest home just as easily as an expensive one. And if you are a more comfortable retiree with a paid-off home worth a lot more, these tax numbers can matter even more to you, because the tax bill your children could face grows along with your home's value. So whether your home is worth $100,000 or $1 million, this video is for you. This is a great moment to hit that subscribe button if you have not already. This channel is completely free, and every single week I break down another hidden rule that affects seniors and retirees, things banks and even some financial advisors never explain clearly. Subscribe now so the next video shows up for you automatically. Now let's get into danger number 1, the hidden gift tax problem. Now let me walk you through step 1. When you add your adult child's name to your home deed, the IRS generally treats it as a gift of part ownership in your home. Think of it like handing your child a slice of a pie while you are both still eating from the same pie plate. That slice has a dollar value, based on your home's value and the share you are giving away. For 2025, you can give away up to $19,000 per person each year without any extra paperwork. That is called the annual gift tax exclusion. But when you add a child to the deed of a home worth, say, $200,000, you are usually giving away far more than $19,000 in one shot. When that happens, you generally have to file IRS Form 709, the gift tax return. Write that number down right now, Form 709. Now here is the good news buried inside the bad news. Filing this form usually does not mean you owe a check to the IRS right away. Most Americans have a lifetime gift and estate tax exemption in the millions of dollars, so filing Form 709 just uses up a little bit of that lifetime amount on paper. But here is the catch nobody warns you about. If you ever apply for Medicaid to help pay for a nursing home, that gift on paper can come back to haunt you. And I will explain exactly how in a few minutes. For now, just remember this. The moment you add a name to the deed, you likely created a taxable gift, and there is a form for that, and skipping the form is not a shortcut, it is a risk. Let's talk about danger number 2, and this one is the big one, the one that surprises families the most. It is called the step up in basis, and if you remember only one phrase from this entire video, remember that one. Here is what it means in everyday language. Imagine your parents bought a house back in 1975 for $20,000. Today, that same house might be worth $400,000. If your child inherits that house after you pass away, the tax law gives them a fresh start. Their cost basis, the number the IRS uses to measure profit when they sell, gets reset or stepped up to the value on the day they inherited it. That means if they sell it soon after for around $400,000, they owe little to no capital gains tax because on paper they barely made a profit. Now, here is what happens if you add your child to the deed while you are alive instead of letting them inherit it. The IRS generally treats the portion you gave away differently than the portion they inherit later. The gifted share often keeps your original cost basis, that old $20,000 number, not the stepped-up value. So when your child eventually sells that portion of the house, they could owe capital gains tax on the huge gap between what you originally paid and what the house sold for. On a home that gained hundreds of thousands of dollars in value, that tax bill can run into the tens of thousands of dollars, money your child never expected to pay, all because of one signature on a deed years earlier. Let's pause here, because this is a good moment for you to leave a comment below. Tell me the year you or your parents originally bought your home, and roughly what you paid for it. Seeing those numbers side by side with today's home values really shows why this step up in basis rule matters so much. I read every comment, so go ahead and share yours now, then keep watching, because we still have 2 more dangers and 2 safer solutions to cover. Now, before I go any further, please listen carefully, because this next danger is the one that scares elder law attorneys the most, even more than the taxes. Danger number 3 is creditor exposure. Once your child's name is legally on the deed, your home is no longer only your asset. In many states, it becomes partly their asset too right now, while you are still living in it. That means if your child is ever sued after a car accident, if they fall behind on debts, if they go through a divorce, or if they file for bankruptcy, your home, or at least a share of it, can potentially become part of that legal mess. A judge or a creditor's attorney does not care that you are the one living there and paying the property taxes. On paper, your child owns part of it, and that part can be reachable. Think about it like adding your name to your child's bank account to help them out. If they get into financial trouble, that account can get frozen or drained, even though most of the money in it might be yours. A house deed works the same way. You are combining your safety net with your child's financial life, whether they are going through a smooth stretch or a rocky one. And here's the part that really worries a lot of retirees. If you ever need to sell the house, refinance it, or take out a reverse mortgage down the road, you now need your child's signature and full cooperation to do it, because legally it is partly their house too. This is exactly why so many seniors are shocked to learn about the Medicaid look-back rule, which ties directly into everything we just covered. If you ever need nursing home care and you apply for Medicaid to help pay for it, Medicaid looks back 5 years at any gifts or transfers you made, including adding a child to your deed. That transfer can trigger a penalty period, a stretch of time where Medicaid will not pay for your care, because the government sees that gift as money that should have gone toward your own care first. So a decision made with love to simplify things for your kids can end up delaying the very care you need later in life. That is a heavy trade-off, and you deserve to know about it before you sign anything. Now let me give you some good news, because this video is not meant to just scare you, it is meant to arm you with better options. Step 2 is learning about 2 tools that many families use instead of adding a child straight to the deed. The first is called a transfer on death deed, sometimes called a beneficiary deed or, in a few states, a ladybird deed. Write that phrase down. Transfer on death deed. This tool lets you name your child as the future owner of the home. But here's the key difference. It does not take effect until after you pass away. While you are alive, you keep full control. You can sell the house, refinance it, or even change your mind about who inherits it. Your child has no legal ownership stake while you're living, so their creditors, lawsuits, or divorce generally cannot reach your home. And because ownership only transfers at death, your child usually still gets that valuable step up in basis on the entire home, which can save them a huge amount in capital gains tax. Not every state offers a transfer on death deed, so this is something to ask a local elder law attorney about directly. The second tool many families use is a revocable living trust. You place your home into a trust that you control completely while you are alive, and you name your child as the person who receives the home after you pass away. Just like the transfer on death deed, this keeps you in full control during your lifetime. It can help you avoid probate court, and it generally preserves that step up in basis for your child. A revocable living trust does cost more upfront to set up than a simple deed change, usually a flat fee paid to an attorney. But many families find it pays for itself many times over by avoiding both the tax trap and the creditor trap we just talked about. If you are a lower income senior on a tight, fixed budget, do not assume good legal help is out of reach. Many areas have free or low-cost legal aid clinics specifically for seniors, and your local area agency on aging can point you toward elder law attorneys who offer reduced fee consultations. You can find your local agency through the Elder Care Locator, a free government service. If you are a more comfortable retiree with a higher value home, the stakes are simply larger in dollar terms, which makes it even more worth the cost of a proper consultation with an elder law attorney rather than a quick and risky deed change done for free at the courthouse. If you have not subscribed yet, now is the time. This channel is 100% free, and next week I am breaking down another rule that catches seniors off guard, this time about required minimum withdrawals from retirement accounts and a mistake that can trigger a surprise tax penalty. Hit subscribe and tap the notification bell so you do not miss it. Let's talk about your 5-minute action step, the thing you can do the moment this video ends. Do not call your child yet, and do not call a real estate office. Instead, call a local elder law attorney or contact your area agency on aging for a referral to one, and simply say this sentence out loud: I am considering adding my child to my home deed, and I want to understand my safer options first. That single sentence puts you in control of the conversation and makes sure you get advice built around your specific state's rules, since deed laws and Medicaid rules can vary quite a bit from state to state. Here is your comment prompt for this section. Tell me below, had you already heard of a transfer on death deed before this video, or is this the first time? I am curious how many families already know about this option versus how many are hearing about it here for the first time. Your comment helps me plan future videos, so please take 10 seconds and let me know. Now, before we wrap up, I want to remind you why this all matters and reassure you about something important. None of this means you did anything wrong if you already added a child to your deed in the past. Many families do this, and many families are perfectly fine. It simply means it is worth having a conversation with an elder law attorney now, while you still have every option on the table, rather than finding out about a problem later when fewer options are available. The tools to protect your home and your family really do exist. Transfer on death deeds, revocable living trusts, and simple conversations with the right professional. The only thing standing between your family and real protection is making that one phone call. Before you go, I want you to do one more thing for me and for someone you love. Please share this video right now with one person in your life who is over 60 and owns their own home. Send it to a parent, an aunt, an uncle, or a neighbor down the street. A quick text with this video attached could save that person and their family a painful and expensive mistake down the road. It costs you nothing, and it could be one of the most valuable things you share with them all year. Let's do a fast recap so you walk away with everything that matters. Adding a child straight to your home deed can trigger a taxable gift reported on IRS, Form 709. It can strip away the valuable step-up in basis. leaving your child with a large capital gains tax bill when they eventually sell. It can expose your home to your child's creditors, lawsuits, or divorce while you are still living there. And it can create a Medicaid penalty period if you need nursing home care within 5 years of making that transfer. Instead, ask a local elder law attorney about a transfer on death deed or a revocable living trust, two tools that generally let you keep full control during your lifetime while still protecting the step up in basis for your family. Before you click away, tell me in the comments which of these two tools sounds like the better fit for your family, the transfer on death deed or the revocable living trust. There is no wrong answer. I am just curious what resonates most with people watching today. And if this video helped you feel more prepared for that conversation with an attorney, that is exactly why I make these videos every single week. If you found this helpful, the next video on this channel breaks down a mistake that trips up retirees with required minimum withdrawals and how one wrong move can trigger a tax penalty you never saw coming. Subscribe now, tap the bell, and I will see you in the next one. Take care of yourself and take care of that home because you worked hard for it, and it deserves a protection plan just as smart as you are.